All right, Mr. White, you have unmuted. You're perfect. You're ready to proceed. So before you proceed with your argument, do you wish to reserve any time for rebuttal, sir?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Very good, sir. And whenever you're ready, we're ready to proceed.
Thank you. May it please the court. My name is Charles White. I represent Benjamin Rose, who is the appellant and the defendant below. Mr. Rose, this is a direct appeal of a criminal conviction and sentence. Mr. Rose was convicted of perpetrating a fraud and grand theft. The victim for the perpetrating the fraud was a restaurant named Dock 633 that was owned by Gregory Brushlick, who was an essential witness for the state in this case. The victim for the grand theft was the state of Florida. Basically, we have raised 5 issues for review of this court. 4 of them are issues that contend that Mr. Rose's right to present his defense was crippled by trial court rulings that excluded exculpatory evidence. And on one issue, which details the prosecutorial misconduct at closing argument that exploited those rulings, and that all by themselves and in combination, these errors together substantially impaired Mr. Rose's right to a fair trial. I want to go to the first issue that is listed, which is probably one of the more significant issues in the case. Mr. Rose was the general manager of Dock 633. He was accused of going into the point of sale computer system and voiding server tickets that were the restaurant patrons paid by cash. He was then accused of altering the amounts and taking the cash for a lower amount and taking the cash for himself. Nobody saw him do this. He made no admissions that he did this. The only evidence that suggested that he might have done it was that he had a PIN code that was entered into the computer system. But anybody who could have gotten that PIN code could have entered into the system, including the owner of the restaurant. But the circumstantial evidence suggested that Mr. Rose was the person. Mr. Brushlick went to the police with documentation to show this, that he gathered himself through the computer system. One of the things that
Mr. White, can I kind of, because I'm sure my colleagues have also reviewed the whole facts of the case, and we've reviewed that. Let me just see if we could kind of steer and get to the heart of the matter. As I understand, your first issue is that you made a request, you subpoenaed a whole bunch of records from the establishment, and you wanted to have, and I see your request right now, you made reference to, you would like to see business tax returns, certain records, cash register reports, 1099 records, signatory, insurance reimbursement debt. You were trying to gather all this information in order to defend your client. And my understanding is that the court indicated that you would be in, a lot of this stuff is really not relevant, and instead allowed you to gather or to receive all the information that the establishment turned over to the state. Am I understanding that correctly?
Yes, Your Honor. In basic overview, you're correct. But I want to clarify, the information, the documents that were requested were specifically requested by Stanley Foodman, who was the forensic accountant retained by the defense in order to review these records.
Let me just ask a question, because you came in the case late. The court made certain references to the number of attorneys and the number of years that it had been pending, and the state also made reference to the fact that they made all of these records available for any expert that the defense had retained, and experts were welcome to come to the state, their office, and review any and all records that they had in their possession that they intended to use in trial. And the judge here ordered the state to make these records available again, except for the tax returns, and then suggested that your experts sit down and go over these records. Did he do that?
I don't believe he did, Your Honor.
Why not?
Because it was not clear what records were made available. The
Well, if
state,
he didn't sit down and look at them, how in the world can he sit here, you sit here and argue that your ability to get a fair trial was impaired? Because your expert, Mr. Friedman's summary was admitted over the state's objection. So all of his opinions were in. Also, his opinions basically were that the account records didn't comport with the tax returns. But also your other expert was able to give his opinion that there was a third device that they used that was unavailable. So how was this his right to a fair trial impaired if your experts got all their opinions in, and then Mr. Friedman did not come before the court and say, Judge, I don't have all these records, because he didn't sit down with the state and review them?
Your Honor, it was my understanding that what the judge had ordered the state to do was provide the records that were considered relevant as discovery. It wasn't the records from the business, it was the records that the state had, and the request went beyond what the state had in their possession. Mr. Friedman was trying to do a forensic analysis of the cash flow in the business to determine whether or not there was even evidence that money was stolen. And he needed these records, which were not part of the state file, and they needed to be produced from the business, not from the state. And that was the difference here. Mr. Breslick testified at the hearing on February 6th, 2017, basically said, I gave the state everything that's relevant to the case, and there's nothing else that's relevant. He didn't say that there was never, that these records didn't exist. He just said they weren't relevant, and those were the records that were made available. Yeah, Mr. Friedman had reference to all of the records that were the state made available, but those were not the limits. The records that were sought by the subpoena were beyond that. That's why
but according to you, Mr. Friedman only reviewed what you had. He didn't bother, and you didn't bother to send him over to the state attorney's office to sit down with the ASA, show me your boxes, everything you have. You didn't bother to do that. The standard review is abuse of discretion. Where did the judge abuse his discretion? Where would no other judge have made this decision under these circumstances?
Your Honor, I think, first of all, I'm only the appellate lawyer. I didn't represent Mr. Rose during any portion of the trial proceedings in this case. However, I believe that the scope of the subpoena ducis tecum was beyond what the state had in its possession for discovery. It was what the state had in its possession that Mr. Friedman was limited to. He should have been given the opportunity of enforcing the subpoena ducis tecum against the business establishment. He would have gotten the extra information that he needed. Basically, his testimony was at trial was that based upon the information that the state made available, that you couldn't tell. You couldn't even tell if anything was stolen. He might have been able to establish that if he had had the benefit of all the information that he was requesting.
And Mr. White, how do you respond to the state's position that in this case, if your expert needed that was not related to the trial judge? That all that the judge had before him, that there's a request for these records, and the attorney at the time, and recognizing, Mr. White, you were not the attorney representing him in the underlying case, but the attorney failed to inform the judge why these specific records are needed. And how do you respond to the fact that the expert could have come in and testified or indicated to the court why these specific records that you were seeking were really vital to his examination?
Your Honor, if you go to the supplemental record on pages 4 to 7,
Yes.
the Ms. Powell, who was the attorney for Mr. Rose, who actually tried the case, I think later on, she detailed by by referencing the memo that she had received, the email from Mr. Foodman, what she needed and why.
And you're right, she did say that she needed it, but then the why part is the one that's missing, because my understanding in reviewing the transcript is that the court was trying to ascertain and she was not able to articulate. And I think one of the issues is that what information, if information was lacking to give to the court in order for the court to have the full understanding, why is it reversible error at this stage?
Well, since the records have never been made available, the ones that were requested, I can't speak to what what they might have said. But I think the main thrust of it, if you go into the time and pay records of the employees, you talk about claims that were made. I guess there was no insurance. There was the monies that were being reported to the state. Don't forget, count 2 was grand theft of sales tax receipts that should have been given to the state on the theory that the amount of money collected was really more than what was reported. But all of those information would have given a forensic accountant the ability to actually give a credible opinion. The problem was this: you could say that he should have done this, he should have done that, but he reviewed the records that were made available. They were limited. It was clearly that they were limited to the discovery. The judge did not order any of these other items to be produced and waiting there at the state attorney's office. It was only the discovery that he was given access to. And the state then basically turned around and said, he said, well, they weren't enough. And the state said, oh, well, you only looked at what your lawyer gave you, and then disparaged his conclusion, which is that the records that were introduced, that without supporting documentation, the exhibits that the state introduced to prove that there was money taken were so unreliable and so deficient that you couldn't even figure out that anything was taken. And the state exploited that in order to say, well, you didn't look at everything, so you don't really know what you're talking about. And that's really how it played out at the trial, Your Honor.
All right. All right.
Well, you had another issue with the records as far as what Mr. Green testified to. I think it was important for any expert to be able to present his data and his conclusions, mathematical conclusions, especially somebody who's a forensic computer expert who's gone through the programs and the software to draw certain conclusions. Experts always, especially experts of this nature, are always able to present their data. In this case, the state had the data, the state had the summary of the data, but the state objected to introducing the summary of the data on the theory that.
But were his opinions excluded? Now, he testified at 459, it's not a summary per se. It renders my opinion based upon the data and analyzed. And then trial counsel went about laying the predicate and introducing all of his opinions. The ultimate opinion of which was there is a third device that's not available, therefore the state can't prove their case. So I don't see where his opinion was excluded, and I don't see where the substance of this alleged summary was excluded.
Well, the summary is of course the compilation of the data, and he had prepared that report, and I think that it was there was no harm to the state, which I think is the standard. There is a statutory notice requirement. The defense, that's under Florida statute 90.956.
Mr. White, was the summary proffered to the trial court? Is it in our record? Is it preserved?
No, Your Honor. there was never an exhibit that I'm aware of that was made part of the record.
And Mr. White, I wanted just to alert you, you're about to get into your rebuttal time. Do you wish to go forward, or do you like to reserve the remainder for rebuttal?
I would like to reserve the remainder for rebuttal. Thank you.
Very good, sir. Very good. All right. Okay. And at this time, Mr. White, I'm going to ask you to mute your microphone. And Mr. Campbell, I see you are unmuted and you're ready to proceed. All right, Mr. Campbell, please proceed.
Yes, ma'am. May it please the court, David Campbell from the Office of the Attorney General. It seemed like we just covered several issues here. As far as issue one, I just read over the motion to compel hearing again. It's just several things I had noted was near the end of it, after defense counsel had read through the letter, explained what she was wanting, and then the state had mentioned, and the judge even commented, there were 4 large volumes of records here that have been turned over to different attorneys over several years. Defense counsel even said she believed she had most of it. The judge, just like in the hearing on the third computer, he basically left it open-ended for her to come back if there was something that was missing. As the court had noted, the judge said, you go over to sit down at the state attorney's office, bring your expert over there. So we don't know exactly when that happened. I know the prosecutor had talked about at one point, one of the counsel's experts had been over there and looked at the machines, and the record even says that the man, I believe the state had started it up. They asked the expert if he wanted to, but he said no, he was just going to make a copy. That was in the motion to compel hearing. So from the defense counsel's own statement, she had most of it. The court just excluded things that were outside of the time period. So as I said in my brief, she hasn't shown how this stuff was relevant, and she did not bring in the expert to more clearly explain why. The court left it open-ended. I don't know what else the court could have done to have her come back and say, we've sat down in the state attorney's office and we still need this. This is what we found out. The judge, I think, was explained very well what had happened. This had gone through 3 years and multiple attorneys. Things were just missing, like maybe pages out of the manager's log. So I said, I don't believe there's been any showing that the judge abused his discretion. He actually left it open-ended. As
Mr.
far as
Campbell,
the summary, it wasn't preserved. I'm sorry.
Mr. Campbell, I saw that Mr. Bressling testified during that hearing and indicated that they had switched systems. Did he maintain and preserve the old system that was in use at the time of the offense?
Yes, sir. From what had happened, the old system was still up for several months after this case had started. And one of I believe the first defense attorney on the case had gone out to the restaurant and seen it in operation. After several months of being in operation, Mr. Bresley decided to switch to a new system. He packed everything up. That was his testimony. He took it to the state attorney's office in boxes. And that was later, as the prosecutor was saying, when one of their experts came to the state attorney's office. As far as the state knew, all of the system was there. Even the judge had mentioned when they were talking about this possible third computer, that this could have been like some of these Apple systems where after you scan the card, it sort of maybe goes into the cloud or something somewhere else. So what else was necessarily attached to it, whether there was another physical unit or not, we don't really know. But of course, the state had everything in a box that was brought to them, and the judge even said in that hearing, to defense counsel, neither you or the state are computer experts. You needed to bring in your expert, or at least the very first defense attorney. You can say, yes, I saw that other system. So once again, the judge, on the information he had, made a reasonable decision. But yes, to my knowledge and what the record says, the original point of sale system was put all in a box and taken to the state attorney's office. And that was even mentioned again in the motion to compel all these records. That would have been there, I think, because the court even said, take your expert there and go to the state attorney's office. So apparently they did not do that. Let's see. As far as the summary goes, that he talked about.
Is that in the record? Is that in the record, as Judge LaBrette asked? I didn't see it in the record.
In the motion to compel, the judge had said your expert needs to sit down with the state attorney's office.
No, I'm talking about witness Green's summary.
I could not find any record of it or mention that it was in the record. And since it was kept out based on not complying with the notice requirements, I couldn't find anything in there. If there was something mentioned, opposing counsel didn't say it and the judge didn't make any mention of it that I saw as far as preserving the record.
So no proffer.
There.
So no
I did not see a
proffer.
proffer, no.
And no
No, in
admission in
fact-
support of the proffer. Okay.
Because what it was when there was the objection, they started talking about whether or not she had complied with the rules. And then when the judge asked her that and she said, no, she hadn't, at that point it was kept out. So actually the contents of it, I don't even think were discussed. But as this court has noted, Mr. Green did testify. He got in all of his conclusions, all of the evidence, the testimony that the defense counsel wanted to bring out. And he did give his conclusion that there was a third computer.
Well, let me ask you this question, Mr. Campbell. In reality, in this case, how is the state prejudiced? Didn't the other side provided the report to the state prior to that? So why?
I believe this.
Okay.
I'm sorry, I believe the state had the summary, yes, or at least notice of what it contained.
So because the state had the summary, why is the state being prejudicial in excluding them from utilizing that summary?
I do not believe that the state, since they had it, necessarily would have been prejudiced that much by the notice requirement not having been followed. I think in my argument on issue 4, I believe the state would have been prejudiced in that this behavior would have kept going on, the almost blatant, not following the requirements. I think that would have been more almost a prejudice to the system itself and to the trial to let the defense counsel keep saying. I'm sorry.
I'm just focusing on this issue here because the rules are such, and the main reason the rules are such is to make sure to give people ample notice to review, to prepare any objections, so forth. But with this one, even though they have not filed this to preserve this in the record, the fact that the state had that summary, it's not prejudicial. The fact that it was excluded, and usually we look at, is that cost prejudice? Was the court wrong in excluding it out? But in this case, I guess the way that I see it here, the state was provided with the report. It was provided with the underlying data. It was provided with the summary. It was provided with everything. And is there anything at this time you could tell me how the state is prejudiced by that summary coming in front of the jury?
Well, actually, I would have to speculate a little bit since not having seen it, I can't say for sure what was in it. But it does appear that since the state had everything, I don't think they would have been substantially prejudiced by it being admitted. By the same token, I don't think since the defense got everything in with their expert testifying, I don't actually think they were prejudiced by it being kept out. The judge just did not abuse his discretion in this case, since he was sort of having to maintain order. As he sort of gave his explanation, I've never had this 3 hearings in one case before. And, this has been going on for many years. There really are no excuses for not complying with the notice requirements and all the other, rules of discovery. So in the end, I don't think the state was really prejudiced, and I don't think the defense actually was prejudiced, other than they put on notice that they need to start complying with the rules. So. And were there any other questions? I think we covered everything that was covered by Mr. White.
Very good. Thank you, Mr. Campbell. I'm going to ask you to then now mute your microphone. And Mr. White, you have your 5 minutes for rebuttal, sir.
Well, there wasn't, I think I've pretty much covered the argument and answered the court's questions as to issues 1 and 2, but there was a mention made by Mr. Campbell of issue 4, which was also a discovery violation. And the idea being that, of course, that was the joint bank account that Mrs. Rose tried to introduce to show that there was no unexplained cash that was being deposited in those accounts. And I think that what Mr. Campbell suggested was exactly what the trial court was doing, and particularly in connection with Mrs. Rose's testimony. Those were bank records. Yes, they had not been disclosed. And so there was a Richardson violation there. There was a discovery violation. The question was not whether there was a discovery violation. The question is what was the remedy? And it seemed very clear from the comments of the trial judge that the fact that this had been going on for a long time, that he didn't think that it was that after such a long pretrial period that there should be any discovery violations, that he was going to punish Mr. Rose by not allowing that information to come in.
And if I may, Mr. White, my understanding of the judge's ruling was a little bit different. I think the judge was concerned regarding whether or not this record is actually appropriate, because when the subpoena was done, it was done and it only showed Mr. Rose. And then didn't the judge say, we don't know when his wife was added? It could have been added right after the subpoena went out. It could have been added. So I think the court was troubled and was concerned regarding, I'm using the word authenticity, but just the propriety of that. So it wasn't just to punish, it's just not knowing as to when she was added, especially when the subpoena was done. Everything that they received was solely in Mr. Rose's name. And my understanding, and reading the transcript, that's what it appeared to me, the judge's concern.
Well, yes, that was a concern, and but that could have been remedied by a short recess to verify with the bank what the truth was about that. It wouldn't have taken that long, and it would have enabled her to put in the evidence that corroborated her testimony, which basically was—
Mr. White, she was able to testify about the bank account, wasn't she?
No, she was actually told that she couldn't use. Not only was the bank account not going to be admitted, but she could not even use the information to refresh her recollection. So she did testify in general terms, but her point was that they put all the cash in that account, and that all that cash was accounted for by his paychecks, by cashing his paychecks, and not all this $30,000 some odd dollars that they claimed that he had stolen. That she said that they hadn't made any big purchases. He didn't have any credit cards in his own name, and so her testimony was very important, and that bank account was very important to show that all the cash that they had was accounted for by his paycheck, and there was no extra cash that would come from this fraud. So I think that certainly the remedy of exclusion is the most extreme sanction that can be handed out in response to a Richardson violation. And I think that the court did not abuse its discretion by not exploring other alternatives that would have allowed the integrity of that document to come in, so it could have been used to further Mr. Rose's defense.
Well, but it was clear that the document had not been produced, and defense counsel, to her credit, fell on her sword. But if you look at 583 of the transcript, after they go through the bench conference with the ultimate ruling, defense counsel again says, did you have a mid-Florida bank account with Benjamin, meaning Mr. Rose? Yes. Was that the only account that Benjamin had? Yes. Which implies they had a joint account. That's where their money went. So with that being said, and that having occurred at trial, how is that harmful? How is the exclusion of the paper documents harmful?
Because they showed that the money there was no money coming in that wasn't accounted for by his paychecks. That was the point of introducing the bank account information in the first place.
And if I may, Mr. White, you've just exhausted your rebuttal time, and I want to make sure that you're able to answer Judge Sleet's question.
No, I had to answer the question as best I could. Thank you.
Very good. All right. Well, thank you, gentlemen. Really well argued. Appreciate you all appearing here in this virtual oral argument. And at this time, I'm going to ask for the second case to come forward. Thank you, gentlemen.
It's time for me, Judge. Thank you very much.
Oh, wonderful. You did great, Mr. White. Thank you. Well done. All right.